Welcome back to Subject to Cross. That's your host, Pete Kratza. I'm his co-host, Caroline Donato.
So you're making me talk first.
Go ahead.
Yeah, I don't really like speaking first, but we were going to talk briefly about an article that I saw in the Daily Local.
What's the Daily Local?
Our local newspaper.
Okay.
Don't make me throw this at you. It was written by Mike Relihan. I don't have the actual date. It looks like it was Monday, July 19th. And the headline is, Are Comfort Dogs Meant for Criminal Trials? Long story short, the Public Defender's Office is appealing to the Supreme Court the issue of whether it was prejudicial to the extent...
I'm gonna stop this.
No, why?
Because it's you got to start broad and narrow in. There was a trial, and in the trial.
Wait, well, hold on. This is why I don't lead. All right,
you
lead.
Okay, and you then narrow it down.
I don't.
There was a trial in Chester County, in which a complainant testified with a therapy dog.
It wasn't a complainant. It was a witness.
Or a witness. It wasn't even the victim. A witness testified with a therapy dog.
It was a murder trial. The complainant was unavailable.
Yes. Okay. Thank you for filling that in. You read the article more thoroughly than I did. But there was a dog, a therapy dog.
Did you even read the article?
I skimmed it.
Yeah.
I saw what.
But you want to lead.
Should we start over?
No.
Okay. There was an appeal after a trial.
Pardon the pun.
Oh my God.
All right. So there's a murder trial. A young girl testifies, and the judge allowed, upon the request of the district attorney, for her to have a comfort dog present with her when she testified. The issue is whether having a comfort dog without predicate justification, and we'll talk about that.
Is there justification for having a comfort dog?
Well, yeah. I mean, you're allowed to. I do further research. Not only do I do more than skim articles, Caroline, I mean, at least one of us takes this thing seriously. I read a law review article on All Dogs Go to Court, the impact of court facility dogs as comfort for child witnesses on a defendant's right to a fair trial. Rather unwieldy title, but it's a law review
Well, it's
article.
a child witness.
Well, yeah, this is child witnesses, but the point is that this was a child witness in the Chester County case, too. The basically the calculus is that the way courts have justified, and there's acts, there's a uniform suggested, I forget the name of it, but there are multiple acts, legislative pieces that are designed to make it easier, and this is reasonable, for children to testify because of the trauma of testifying, whether it's remote testimony, whether it is testifying with only the defense lawyer and not the defendant in the room, like a videotape deposition, or testifying via closed circuit TV from another room that progressed to them being allowed to bring dolls up, to help them relax, to having guardian ad litem in the courtroom with them, even up to the stand. And all these accommodations are justified by our legislators and then judges on the theory that a calm and non-hysterical witness is more likely to advance fact-finding. The issue, obviously, I mean, they're obvious to this defense attorney anyway. When, for instance, someone is allowed to bring a doll, or in this case, an animal, to the stand with them, the arguments are, and the arguments advanced by the Public Defender's Office are not unique, that they're buttressing the credibility of this witness. They are engendering sympathy of the jury for the witness. They are basically, the argument can be made that they're basically showing what a scary guy the defendant is, that this person needs to bring a comfort dog up to testify against them. So there are a lot of due process arguments, that this would upset a fair trial by having a dog. And by the way, why aren't there comfort cats?
Oh, no one's comforted by a cat but you.
I literally, that was very upsetting to me. I need my comfort cat. I don't dogs. Why do you need a comfort dog? The cats,
I just want these principles.
They sit in your lap. They purr. Whatever.
Wilbur purrs.
So So the argument, this is from the article, not only do these attributes naturally engender sympathy, but this scenario has a very real probability to lead the jury to prejudicially infer that the witness is so afraid of the defendant that he or she needs the extraordinary measure of a dog to testify against the defendant. Our district attorney, Deb Ryan, is quoted as saying, "What we're hoping with this case that we handled here demonstrated there's clearly a need for certain vulnerable victims or witnesses to have the additional comfort of a dog." This was in an interview to another publication. "We already afford that special kind of accommodation for certain types of cases, so this may be something that levels the playing field for us."
How does that line make you feel?
Let me continue first. "This is all about us being truth seekers and trying to figure out what happened," Ryan said. "There are certain victims and witnesses who are vulnerable or fragile or have fear or anxiety, and without having the assistance of a comfort dog are incapable of testifying. So for us, this is potentially a huge win for victims and witnesses in our pursuit of justice."
Smells
Okay.
like Marcy's Law.
So here's the deal. One, they didn't make an adequate. The PD is arguing that the prosecutor's office in this case didn't make a record to establish that the judge, should have allowed the comfort dog. There are, for lack of a better word, hurdles that you need to establish. That she has a rapport with the dog, that she is traumatized. Other than I think they said when she called prosecutors told the judge that she was so traumatized at having to confront the defendant that she needed the assistance of a Labrador canine officer with the county sheriff's office. And what the PD says is when asked by the court to identify the specific reason for the request, the Commonwealth did not specify the witness's age, developmental disability, only the witness's concern for her safety. There was also no testimony regarding whether utilizing the comfort dog would help her provide truthful testimony. Of note, there was no evidence that she had interacted with the dog in the past and the dog had calmed or alleviated her fear. Those are normally what you establish when you bring in, for instance, if you have a child victim, she has an attachment or he has an attachment to this dog. The dog's going to facilitate calm and credible testimony. It's going to advance fact-finding, truthfulness. There was no such showing here. They just said, she's afraid, let her bring a dog up. The other thing that I can't understand, what the Commonwealth argued in their brief, our friend Mr. Walshberger, first, while dogs are a well-liked species, not every person likes them. Guilty, Your Honor. Or feels comfortable. It's not that I don't like dogs, it's that cats are better. Second, and of vital importance, in this case, the trial court did not make any reference to the dog being a comfort dog, but rather a service dog. Oh, well, I'm sure that made all the difference in the world. But then this is the one that got me. Third, and most importantly, the comfort dog was never seen by the jury, he said.
How's that possible?
She was testifying in the courtroom. Did the dog come up from the basement? Is there a secret dog compartment in the floor? And how do you know the jury? Did they poll the jury to see whether the jury saw the dog? All right, whatever. But the point is that, a couple things. One, level the playing field. I told you that with all due respect to Miss Ryan, that got to me a little bit. The level playing field. Normally, when we're in a courtroom, the defendant has you, maybe me, right, or one or both of us. We might have one investigator. The Commonwealth of Pennsylvania has a prosecutor's office with 30 lawyers, however many investigators, a local police department. They got a jury that
crime victims
advocate. They're not really going to like our client based only on the accusations. Most of the judges are former prosecutors. I'm like, level playing field.
Not
you
only
talk
that,
about a level playing field,
Pete. Not only that.
Sorry.
No, I'm glad you're passionate about something today. Not only that, but the prejudice of the terminology itself, victim and defendant.
You mistake sassiness for passion. I was passionate in the courtroom today, not sassy.
When you were sitting back with your legs folded, looking at your phone?
I was attempting to look dispassionate, but I was engaged, man.
But, yeah, level the playing field is one thing.
Again, that's with all due respect, and it's a throwaway line, but the point is, I got news for the listener. The playing field ain't level. All right, it ain't level, and it ain't level. It's not tilted toward our side. It's to the other side.
It's to the
They have
prosecution.
resources that I don't care how wealthy you are and what you can afford for us to do. We're never going to match the manpower that. Am I still allowed to say manpower, or is it person power? Is manpower? I mean, it's a term. You're giving me a look like I don't know whether I said something wrong or not.
I want you to navigate this journey on your own.
Okay. Until you interrupt me. But the point is that I do have an issue. I understand, and I do not disparage that it is difficult for children to testify, particularly when they themselves are the victim. But on the other hand, bringing a fluffy dog up to the witness stand, and you know they're not gonna bring like some Rottweiler up there. It's gonna be some black lab or some dog that dog people like, and it is going to engender sympathy. It is going to tell the jury that what a bad guy this is. Poor Missy needs to bring a dog up just to testify against him. So it's a slippery slope, man. I really, in reading the law review article, the justification doesn't really resonate with me.
What is that article? Oh.
The justification is that it advances fact-finding because it's a calmer witness and you're more likely to get the truth. Well, guess what? They can be calm by testifying closed circuit. They can be testified by having me in the courtroom with them. I think a dog, it can be distracting. It can distract the witness. It can distract the jury. And I don't think it's a very good idea.
What about if it's okay for Commonwealth or government witnesses who are traumatized to use a dog? Can it also be applied to a defendant who's testifying?
I don't see why not.
Can we file some motions in limine?
No. A cat. I want a therapy cat.
I want Wilbur to get his license, and then we bring him in. He sits on the lap. Everybody sees Wilbur. He snores. It's not distracting at all. And he gives comfort.
Are you going to bill separately for Wilbur?
No.
Is there going to be a separate fee agreement?
No, it's a perk.
What's Wilbur's hourly rate?
No, it's a perk.
Oh, it's a perk.
Yeah.
So next I can see you're going to put Wilbur on the website, right?
Right under our
Yeah,
faces.
No, that's not going to happen.
But
all right.
Can I say the line that irks me?
Irks?
It irks
Okay.
me. This is all about us being truth seekers and trying to figure out what happened, Ryan said.
Well, I mean, I'm sure that's what they think they're doing. I don't find that particularly irksome.
Well, I didn't find your level playing field as irksome as that one.
Fine. No, I mean, so again, I'm reading this law review article again. Dogs help children throughout the judicial process. Having coherent, articulate witnesses. That's what the benefit of dogs are. I don't buy it. Maybe it's because I'm a cat person. We've never had that issue in our practice, having a comfort dog, but it sounds like maybe the kennel doors are opening now, and they're going to try to bring more and more of them in every time they have a child witness, and I'll object every time.
And I'll make a counter motion in limine to admit a dog with our witnesses, who are equally as traumatized.
Did I tell you about the time that I think you weren't in a courtroom, I don't think, but I had a hearing in front of a judge, and I had to use my own computer, and all my cat pictures are on there?
Yeah.
Did we talk about that?
Yeah, we've talked about it.
Yeah. I have more cat pictures.
You thought that was real silly.
My family's away. I sent them cat pictures.
There could be worse.
What?
There could be
Oh,
worse.
yeah, absolutely. It could be worse. Yeah.
So speaking of comfort, one of the things I just wanted to tack on to the end of this episode, unless you have more to say on this.
No, I'm good. I'm all dogged out.
We'll just sit in that for a second.
Dog tired. Do you want me to start with puns?
I want you to stop.
All right.
One more point of comfort. So I'm learning that clients of ours are listening to this podcast. And one of the themes we touched upon in previous episodes is about a client being truthful with their lawyer. Some lawyers don't want to know the truth. We are lawyers who do want to know the truth. And I have learned...
I am dogged in my pursuit of the truth. All right, I'll stop.
Could you just...
I'll stop.
Could you just tell me how much more you're going to do of that today so I can manage my expectations?
Our colleague Duke Schneider is the master of the pun. I can't even begin to compete, so I'll stop.
Okay. one thing that our clients are reacting to is when they do tell us the truth, and me in particular, and I don't react mad ever.
You're not rough on them?
Oh, jeez.
That was good.
That was good.
Wait, okay. So what you're saying is that they're afraid of your reaction if they tell you the truth?
No, I think people who are
Maybe
accused
you
of
need to be nicer.
No, it's not me. It's not a personal thing.
No.
I think I have some quite fine bedside manner, but it's when you're accused of a crime or someone's being accused of something and there's a different side to it. They don't know how that side's going to be portrayed, and in building that trust with the client, when they describe that side, I've had multiple clients recognize that it's not a bad thing to be completely honest with your lawyer. In fact, it's a comfort. And I just want to reiterate that, especially because we have many of them who are now listening to the podcast and finding comfort in learning about their lawyers.
My God, our clients listen to this?
Yes. That's why I'm tacking this on to...
I'm not convinced anybody listens to this.
They don't tell... Your clients aren't telling you that?
Well, no, because one of the... I would have hoped that you've learned this from me already. One of the first things I tell clients is that I want the truth. You know, I don't want half-truths. I don't want what you think I want to, hear, because my advice is going to be based upon the truth.
Right. Well, I start with that too.
Oh, well, apparently my clients listen to me and your clients don't trust you.
I don't know where you got that from, because at no point did I say that.
I think we're getting to the point of diminishing returns. I've been in this room way too long.
Yeah.
I am like a caged animal.
Well, we're going to probably chop most of that out. All right, Pete, anything else you want to add until we podcast in another 5 months?
Yeah, right. So it's been like how many months?
It's been since March.
We need to be more consistent with this. I think we should start having guests.
Okay.
Yeah.
Well, listener,
I'm sure people are bored as hell listening to you and me.
I'm bored listening to me. I told you on the way here, I don't need to be here. You could run this whole thing and I would be just fine.
Well, first of all, I wouldn't be able to turn the machine on.
It's the red button.
There's 3 red buttons.
No, there's 3 red lights. There's 1 red button.
There's no way I'd figure that out.
Okay. But I will say...
You know what that looks like? A Walkman. Were Walkmen around when you were like a teenager or listening to music?
iPods were around when I was a teenager.
Yeah, so we had Walkmen. They were like bulky.
That's
like
why you're jolly 50s, man.
Now I'm throwing this at you.
But if I never had to hear my voice on a podcast again, I'd be happy. I'd be happy to step aside. You come in here by yourself with a guest.
Well, I don't listen to this unless you tell me I have to listen to
No, we have to see what we've said before.
That's what you're for, man. I don't listen to this.
Okay. Well, listen, it's Friday afternoon. It's past 2:00. Your bedtime's coming.
I have to work still.
All right, listeners, signing off. If you have any questions, if you want to hear any special guests, investigators.
Bill Cosby.
No. Investigators or expert witnesses, other lawyers, whatever you're interested in, email us at subjecttocross@mcelree.com. Signing off. Say bye, Pete. Be nice.
Goodbye.